A very good morning to all my dear students. Today we are going to discuss about the drafting of an agreement to sell under the subject captioned as drafting, pleading and convincing. As you all are aware that this is a topic given under Unit 4 of the university syllabus. But before starting with today's lecture, I just want to apprise you with the law relating to agreement to sell and sale agreement or sale deed. My dear students, as you all are aware that primarily the property is divided into two parts. One is movable property and another is immovable property. As regards the law relating to movable property is concerned, the same has been laid down under section 4 of the Sales of Goods Act, whereas the law relating to immovable property, that is with regard to agreement to sell and sale agreement, has been laid down under the Transfer of Property Act. As regards an agreement to sell is concerned of movable property, I would like to submit that one of the foundation concepts in the Sales of Goods Act is the sale and agreement to sell. Section 4 of Sales of Goods Act 1930 specifically deals with sale and agreement to sell. It explicitly manages and deals with sale and agreement to sell. It expresses that firstly, an agreement to sell products is an agreement whereby the merchant moves or consents to move the property in merchandise to the purchaser at a cost. There might be an agreement of offer between one section proprietor and another. Secondly, an agreement to sell might be total or restrictive. Thirdly, where under an agreement to sell, the property in the merchandise is moved from the seller to the buyer, the agreement is known as a sale. Yet, where the exchange of the products or the property in the products is to happen at a future time or subject to some condition from that point to be satisfied, the agreement is called an agreement to sell. Lastly, an agreement to sell turns into a sale when the time slips or by the conditions are satisfied depending upon which the property in the merchandise is to be moved. Now, I would like to apprise you with the essentials of the contract of sale. Number one, there ought to be at least two parties. Number two, the basis of the contract ought to be products. There must be a price and there must be transfer of property in the goods, absolutely or conditional. All other essential constituents of the valid contract must also be satisfied. Section 4 clause 1 defines sale as a contract whereby the seller transfers or agrees to transfer the property in the goods for the buyer for a price. Thus, my dear student, it happens in the present. Such an event of sale is fixed, conditional and binding upon the parties. A contract of sale is made by an idea of to purchase or sell merchandise at a cost and an affirmation of such an offer. An agreement to sell can be defined as the transfer in the goods that is to take place in future time, or the transfer might take place depending upon the fulfillment of certain conditions. The same had been defined in section 4 clause 3. An agreement to sell also becomes a sale when the given time elapses or the conditions that are needed for the transfer to happen gets fulfilled. Thus, an agreement to sell establishes the terms and conditions of the offer of a property by the seller to the buyer. Now, what is the difference between sale and agreement to sell? As per section 6 clause 1, the sale deed mostly comprises of the existing goods owned or possessed by the seller or future goods. Whereas in the agreement to sell, the seller indicates to impact a present offer of future merchandise. Thus, it entirely depends upon the contingency of the event, which may or may not happen. However, under Section 8 of the said Act deals with the goods perishing before the sale. But before the agreement to sell, thus this section also highlights the goods which damages or perishes without any fault of the seller or the buyer. Thus, this happens to be an instance of an agreement to sell. So, my dear student, this is the law relating to an agreement to sell of movable property, and the similar law pertaining to the immovable property has also been laid down or given under the transfer of property law as such. Now, with this background, we are now going to start with our today's topic, that is drafting of an agreement to sell, wherein I would like to provide you the format, how it looks like, or how this agreement to sell needs to be drafted. As you all are aware that it is the component of the deed wherein we have to give or to describe the deed as well. And as far as the description of an agreement to sell of this deed is concerned, we have to mention this deed as an agreement to sell, an agreement of sale of immovable property. And thereafter, after the description, in the description, we have to mention the date of the deed as well. In that also, we also have to mention the parties to the deed. So we have to start with the same as this agreement of sale executed on this day of this month of this year between so and so. Here I have given the name as S, son of SF, resident of so and so. Hereinafter called the vendor or party number 1 of one part, and P, the son of PF, resident of so and so. Hereinafter called the purchaser or vendee or second party of the other part. The expression vendor and the purchaser, or the first party or the second party, as the case may be, wherever they occur in these presents, shall also mean and include their respective heirs, executors, administrator, legal representative, and assignees as well. Whereas the vendor is the sole and absolute owner of the property, more fully set out in the schedule hereunder. So in this, the recitals, we have to mention about the title of the owner. And whereas it is that the vendor shall sell and purchase the said property for a sum of rupees so and so, which is free from all encumbrances. So this is the consideration amount for the said property. Thereafter, testatum. Now this agreement of sale witnessed as follows. The price of the property more fully set out in the schedule is fixed at rupees so and so, and which is free from all encumbrances. Number 2, covenants. The purchaser has paid to the vendor this day the sum of rupees so and so by way of earnest money for the due performance of the agreement, the receipt of which the vendor doeth hereby admit and acknowledge. Thereafter, the time for the performance of the agreement shall be so and so, 2 months, 3 months, you may mention over here 4 months, as the case may, my dear student, from this date, and it is agreed that time fixed herein for the performance shall be the essence of this contract. So this is also one of the terms and conditions which may put in the agreement to sell, that this contract, in this contract, the time is the essence of the contract, and this contract needs to be completed within a so much specified period, which has been specified by the parties, respective parties to the deed. The purchaser shall pay to the vendor the balance price of rupees so and so before registration of the sale deed. The vendor agrees that he will deliver vacant possession of the property to the purchaser before the registration of the sale deed. So this is also one of the terms and conditions which needs to be put in the recitals of the deed. The vendor shall execute the sale deed in favor of the purchaser or his nominee or nominees as purchaser may require. The vendor shall hand over all the title deeds of the property to the purchaser or to the second party as the case may be, or to his advocate nominated by him within a period of dash days from the date of this agreement for scrutiny of the title, and the opinion of the vendor's advocate regarding title of the property shall be final and conclusive. The purchaser shall duly intimate the vendor about the approvals of the title within a period of so and so days after delivering the title deeds to him or to his advocate. So my dear students, these are all the terms and conditions which may be put forth as may be determined or as may be fixed by the respective parties to the deed. Thereafter, if the vendor's title to the property is not approved by the purchaser, the vendor shall refund to the purchaser the earnest money received by him under this agreement, and on failure of the vendor to refund the earnest money within dash days, he shall be liable to repay the same with interest thereon at the interest rate fixed by the respective parties to the deed. Further, if the purchaser commits a breach of the agreement, he shall forfeit the earnest money of rupees so and so paid by him to the vendor. So my dear students, from this we may infer that we may also put the terms regarding the breach committed by both the parties to the deed, breach of the contract to the deed. If the vendor commits a breach of the agreement, the vendor shall not only refund to the purchaser the sum of rupees so and so received by him as earnest money, but shall also pay to the purchaser an equal sum by way of liquidated damages. Nothing contained in para 9 and 10 supra shall prejudice the rights of the parties here to the specific performance of this agreement to sell, meaning thereby you may put in the agreement to sell regarding the specific performance of the contract also, which is a remedy provided under Specific Relief Act 1963. So this is all about, my dear students, about today's topic. Hope you have learnt a lot out of it. In case of any query, then you may write it to me at my email ID, that is rahul.arora.gn@jagannath.org. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on drafting of the sale deed. Thank you very much. We'll meet you soon in my next lecture on drafting of the sale deed. Till then, stay home, stay safe, and stay healthy. Thank you very much again.